Hello everyone, welcome to Court with Krissy. It's now the final day of jury trial, day 3. We start with a plea offer, and then we end with a motion to have him acquitted. And there's one more video left, so you do the math. I hope you like it. Court with Krissy is now in session.
71, 84, 78, and 58, continuation of jury trial in this matter. Members of the jury are not present. Counsel record, they are present. The defendant is present as well. We had a brief discussion yesterday and this morning, and there was discussion of potential resolution to the matter. However, I'm not sure whether that's going to proceed in that fashion or not. However, let me make it clear. I believe that people want to place on the record a potential plea offer, and we can proceed from there first. Mr. Rotowski.
Yes, Your Honor. Your Honor, the offer that the people have extended to the defense is that in file 7178, defendant may plead guilty to home invasion first degree, assault which is 10th degree bodily harm less than murder, and count 3 in that file would be dismissed. In file 7158, the defendant would be pleading guilty to aggravated stalking and using a computer to commit a crime with the imprisonment of 4 years or less, but less than 10 years. And in the last file, which is 7184, the 2 charges, home invasion in 2nd degree and unauthorized access to the computer, would be dismissed. Defendant would agree to pay full restitution in this matter.
Thank you. Ms. Roberts.
Your Honor, I've had an opportunity to speak with Mr. Talisman at length. We had a telephone conversation regarding the potential plea offers, what the potential guidelines would be, what the pros and cons would be of him taking the plea as opposed to letting the case go to the jury. And it is his decision to not avail himself of the plea offer.
Very well. Ms. Roberts, do you wish to place your client under oath to cover that as well?
Yes, please.
Thank you. Mr. Talisman, do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, Your Honor.
Thank you. Ms. Roberts, you may proceed.
It's okay if we just sit?
Yes.
Do this? Mr. Talisman, we talked on the phone a couple times last night.
Yes.
And during the conversation, I had explained to you the offer of the prosecutor's office regarding this matter and the potential guideline sentence that you would or might receive.
Yes.
And we had an intense conversation about that matter. You had the ability to ask questions.
Yes.
And did I satisfactorily answer your questions?
Yes, you did.
And your decision to not accept the offer was what?
Not to accept the offer.
And you want to proceed and finish the trial?
Yes.
Thank you,
Thank you. Thank you. All right. Also, this court routinely in any criminal trial before the end of the conclusion of the people's proofs will turn it over to defense counsel relative to any issues pertaining to the defendant testifying or not testifying. Ms. Roberts, would you mind addressing that now, or would you rather wait as we proceed through the trial?
I prefer to do it right now.
Please.
Wait, but they-
And he's under oath, so you may continue.
And we've had several opportunities to talk about whether or not you were going to testify at trial.
Yes.
On several occasions before, even last night, correct?
Correct.
And last night, we talked about it a little bit, not at length, but you do understand that you do not have to testify.
I understand.
And that if you didn't testify, you would still be presumed innocent. It has nothing to do with whether you're guilty or not guilty.
Correct.
And it's still your desire to testify in this matter, knowing that you don't have to,
Yes,
and knowing that everything you say or can may be held against you.
yes.
Your Honor, any questions?
No questions of the court?
Thank you.
Very well. Thank you. All right, the members of the jury, we've had a few filtering in already this morning, so anticipate a few more. We'll, as soon as they are ready and we have all 13, we'll proceed accordingly. We'll take a quick break and go off the record. Thank you. Court recalls the matter people state of Michigan versus David Walter Talisman. Members of the jury have returned for day 3 of jury trial. Good morning, members of the jury. Hope you had a great evening last night. As stated, we are still in the prosecution's case in chief. All counsel are present in the courtroom. The defendant is present as well. Mr. Rukowski, or Mr. Hunt, the next witness.
Yeah, sure. And people call Officer Phil Z. Thank you, Your Honor. Good morning, sir. Can you please state your name for the record and spell your last name for the benefit of the court reporter?
Phil Deacons, Deacons.
And Officer Deacons, how are you employed?
Through the city of Bad Axe.
And what is your position there?
I'm a jack of all trades, if you will. I'm a road patrol officer, but I'm assigned basically just to do investigations involving digital.
And how long have you been in law enforcement in total?
Since 2014, so a little over 11 years.
And how long have you been with the Bad Axe Police Department?
All 11 years.
Now, you mentioned some of your special duties. Can you please describe those duties and responsibilities as it pertains to the forensic examination of electronic devices?
Yeah. So I've received training in the examination of cell phones, computers, electronic service records such as like Snapchat, Facebook, call detail records from cell phone providers.
And that's advanced training beyond your standard law enforcement officer training?
Absolutely.
Can you describe some of that training that you've undertaken that in that particular field of forensic examination of electronic devices?
Sure. So I've specifically training focused on call detail records from cell phone providers. That would be the examination of the records. That would be your phone calls in and out, text messages, and location data that might be associated with it. I've been through the National Computer Forensic Institute for training for the examination of mobile devices, such as cell phones, GPSs, tablets. I've also been down there, now I should say that the mobile device one, it was a full month in Alabama every day. I received training in the basic computer evidence recovery. That was 5 weeks put onto the Secret Service Institute. Among others.
Okay. Now let me ask you, were you brought in to conduct a forensic examination of devices on an investigation involving Shanna LaViolette and the defendant, David Talisman?
Yes, it was.
What is the first device that you examined and to whom did it belong?
It was an iPhone that belonged to Shannon.
And on what date did you examine that cell phone?
July 4th.
Okay. And just so the jury kind of understands how it works, can you describe how you conduct a forensic examination of an electronic device, in this case, the cell phone? What kind of steps do you follow?
When I first take it in, or whatever officer receives it, we make sure that it's in airplane mode, and then we turn off Bluetooth and Wi-Fi.
How do you do that?
That prevents the change of data on the phone from an outside source. So it takes it off network, so that way there you couldn't have like a remote wipe or other applications, new notifications coming in, new text messages. It wants to be in the state that it was when I first received it. So nothing changes from an outside source.
And is it fair to say that Ms. LaViolette provided her device to you?
She did.
Okay. Is there, so what the steps that you were describing, is that the industry standard for conducting an examination of an electronic device?
Yep. The biggest thing is getting it off network so no other outside influence can affect it.
And do you follow a set of standard protocols when you're examining any kind of electronic device?
I do.
Okay. And did you follow those protocols when you examined Ms. LaViolette's cell phone?
Yes, I did.
Now, were you able to examine the location data that was extracted from Ms. LaViolette's cell phone for the time and date leading up to this alleged home invasion in Sanilac County, that being July 2nd of 2024?
Yes, I did.
Okay. Were you able to make a determination as to the location of Ms. Laviolette's cell phone during these times in question?
I was.
Was there a particular time that you were looking for?
There was a window of time that I looked at, yes.
And why were you looking at that particular window of time?
Based on the information I was given, that was the time frame. It'll have been a little bit before to a little bit after what I've been provided regarding the home invasion.
Okay. And so at the time of the alleged home invasion, right around 9 p.m., were you able to locate Ms. Laviolette's cell phone?
I was.
And where was it located at that point?
It would have been on basically Forestville Road between Tyler and Freiburg Road.
Is that consistent with the address that you learned of the alleged home invasion in Sanilac County from their investigation?
It is.
Okay. Now, in the time period leading up to the alleged home invasion, did you also look at her location data pertaining to her own residence?
Yes.
And what is her residence address? And at any time leading up to this alleged event in Sanilac County, did her cell phone appear to be at her residence?
Not during the time period I was.
Okay. Now, what's the second device that you examined and to whom did it belong?
It was an iPad and it also belonged to Ms. Laviolet.
And on what date did you examine this iPad?
On July 4th.
And is the manner in which you conduct a forensic examination of an iPad any different than that of a cell phone?
Nope, I followed the exact same steps to make sure it's off network. There are some iPads that have the ability to do cellular, so follow the exact same steps.
Okay. And is it fair to say that Ms. Laviolette provided this iPad to you?
Yes, she did.
Okay. And were you able to examine the location data extracted from Ms. Laviolette's iPad for the date and time leading up to the alleged home invasion in Sanilac County?
Yes, I did.
And that's the same window of time that you were looking at for her cell phone?
Correct.
And were you able to make a determination as to the location of her iPad during that time?
I did.
And where was that?
That was very consistent for the entire time period, right around.
And it did not move from that location during the time frame that you examined?
Correct. The movements were negligible, basically just points around that residence.
And so during your examination of the iPad, were you able to access the application usage log?
I was.
And can you explain to the jury what is the application usage log when we're talking about an iPad?
So part of the iOS operating system basically logs all of your interaction. So if you were to unlock the device, we'll even back a step. If you were to turn the device screen on, that gets logged the exact date time the screen turns on. When you put in your passcode, it then logs that you had a successful passcode entry and the date and time for that. When you launch an application, it'll tell you the date and time it was launched and where it was launched from. It was your home screen, there's your springboard at the bottom, which should be like your shortcut buttons. It tells you if you use your camera, when your camera was activated, if it was the front camera, the back camera.
So while you were looking at the application usage log for Ms. Laviolette's iPad during this time frame that you mentioned, did you notice anything that was related to your investigation?
I did.
And what was that?
I noticed that almost all of the above stuff. So the screen was turned on, the password was entered, and some applications were opened during a time period I knew would be inconsistent with Shana being home with that iPad.
And what time did that particular did those things come to your attention from the iPad application usage log?
I would have to look at the exact time.
If you were to look at a copy of your police report, would it refresh your recollection?
Absolutely.
Do you have a copy of it there with you?
I do.
Okay, if you'd use that to refresh your recollection, then just let me know when you're done.
So the screen turned on at 8:47 p.m. on July 2nd.
And did you compare the location data from Ms. Laviolette's phone as to where it was located at 8:47 p.m. on July 2nd of 2024?
I did.
And where was her phone located at that time?
Her phone would have been either at, but it was down in that area.
But not at her residence? Right. Okay. And so what particular, if any, applications did you see accessed on the iPad starting at about 8:47 in the evening? on July 2nd of 2024?
The first application was open with Facebook, and then the second one would have been Snapchat.
Now, when you look at those in the application usage log, you can see that the applications were opened and accessed. Is that correct?
Correct.
Can you see what a person did when they're accessing or opening those applications?
It depends on the application as to which one gives access to the operating system to log things. So with Snapchat, I know that they record if you use the camera.
So if a person was to access, say, the Snapchat app on the iPad, what sort of information would they be able to learn? Or what would they be able to see if they access that app on the iPad?
Snapchat provides a lot of information. So you could see conversations that were being had between people. You can also see if you have your location turned on for your Snap account, you can see locations of other people.
And is that the same to say of Facebook?
Facebook doesn't give you location, but you could see, conversations and such with other people.
Could you see somebody's public Facebook posts if you opened that particular app?
Absolutely.
Okay. So based upon what you know of Ms. Laviolette's location from her cell phone, could she have been the individual accessing the iPad?
I would say that's extremely unlikely.
Now, at some point in the future, did you come into possession of a cell phone owned by the defendant?
I did.
And how was that provided to you?
That was turned over to the Detective Bureau by Sergeant Flores.
Okay. And were you able to conduct a forensic examination of the defendant's cell phone?
I was.
And did you follow that same set of standard protocols that we've already discussed when you examined the defendant's cell phone?
Yes.
And on what date did you perform the forensic examination of his device?
It would have been in November of 2024.
And what was the name of the defendant's device? Did it have a name associated with it?
I believe so.
Would it refresh your recollection to review your report?
It absolutely would.
And I would ask you to please do that and let me know when your recollection is refreshed.
The name of the device was David's S22 Ultra.
Were there any email addresses associated with the device?
There were a couple.
And would it refresh your recollection to review your report to determine those email addresses?
It absolutely would. I appreciate it. I do a number of phone examinations.
Understood.
So there were 3 that were associated with this device.
And what were those email addresses? And were you able to determine if a Facebook account was associated with the device?
There was.
Was there a username for that Facebook account?
There is.
And what was that username? Were you able to determine if a Snapchat account was associated with that device?
There was.
And what was the username for the Snapchat account?
It was.
Now, were you able to examine the location data extracted from the defendant's cell phone for the date and time leading up to the alleged home invasion in Sanilac County?
Yes, I was.
Did you also examine the location data for the date and time following the alleged home invasion in Sanilac County up until the defendant's interaction with the Bad Axe Police Department?
I did.
Were you able to determine the location of the defendant's cell phone during these times?
I was.
How does the defendant's cell phone maintain location data?
So with it being a Samsung, they use the Samsung proprietary thing. It's called Rubin. And what it does is it just grabs GPS locations of that device for multiple interactions. It could just be checking in, it could be application usage, but it saves it within the Rubin area of the phone.
And is it fair to say that there's another manner in which cell phones collect location data? Other than GPS, I mean, I'm sorry.
Oh, yes. Yes.
And what other manner does one's cell phone track location data?
Through connection to the provider's cell phone towers.
And of those two, the cell phone tower data or the GPS data, in your experience, which one is more accurate?
Especially in our area, GPS is by far the most accurate.
And why is that for the area of the thumb?
We have fewer cell phone towers to use to create location data from.
But the GPS data does not require the use of the cell phone tower?
Correct.
Okay. And Now, what did you do with this location data after you extracted it from Mr. Talisman's phone?
First step was to filter it. The number of points that these phones collect, it's just astronomical, the number of points they create. So I filtered it down to the date and time that we actually need to know about. And then honestly, from there, I can filter it again to exclude points that are more consistent than like every 30 seconds to a minute.
And after you were able to filter down these data points, what did you do with them then?
I then would have exported them out and I actually put them into some mapping software. I used a couple different ones.
Okay. Now, the first map, does it represent all of the location data that you extracted from the defendant's cell phone?
No.
And why is that again?
There are just so many points, it wouldn't make any sense to look at without filtering it down.
Now, in your estimation, what's the level of accuracy of the location data that you were able to extract from the defendant's cell phone?
In terms of GPS points, I think they're all accurate to within approximately 100 meters or less. Some of them are down to in the single digits for meters of accuracy.
And were you also able to examine the location data that came from the cell phone towers?
I was.
Was the data that you received from the cell phone towers consistent with the data that you received from the GPS data?
It is.
Okay. And may I approach the witness?
You may.
Officer Deakins, I'm approaching with what's been marked as People's Proposed Exhibit 75. Do you recognize that disc?
I do.
And what is that disc?
This would be the mapping data that I would have gotten from the cell phone.
And what else is contained on that disc?
There were maps that were created using the data as well as the data points used to create the maps in an Excel spreadsheet.
And so what are the contents then of the Excel spreadsheets that are also located on those?
They were all the contents of the Excel spreadsheet, just the data points pulled from the phone. I just use Excel as a source for creating the map.
Okay. Is it fair to say that the information, I'm sorry, strike that. You created this visual representation yourself, correct?
Yes.
And is it a fair and accurate representation of the location data that you extracted from the defendant's cell phone?
Yes, it is.
People would move to admit People's Proposed 75.
Ms. Roberts.
No objection.
Thank you. 75 is it?
People would ask the court's permission to display to the jury.
You may.
So Officer Deakins, describe, I'm going to zoom out of People 75 a bit to try and get the entirety. Can you describe to the jury what they're seeing on People 75?
So these were all the data points from the phone that after it was filtered down from July 2nd at 1940, the first point, through July 3rd, and the last point, I believe, somewhere around 6:43 a.m.
And so the point that we see, let me back up. There's some different colors on the map. Is that fair to say?
There are.
And what do those colors represent?
For clarity, I use different colors to describe the movement. So one color was the initial movement.
And what color is that?
Appears to be purple. It's a little bit hard to see from back here.
Understood. If you need to step forward, I would ask the court's indulgence if the witness needs to have a clearer view of the exhibit.
Yeah. So the first points would be purple.
And those would indicate, those are starting, you said, at July 2nd of 2024 at 1940. That's military time. What time is that in standard time?
That'd be 7:40 p.m.
Okay. And so those purple points, and then we have another color.
Then you're gonna have red.
And what do those points represent, or what does the red color represent?
So that was the next set of movements. So the purple would have been starting, which would be Mr. Talisman's residence, the area of his residence, traveling over, and then up north into Vadex, they stop approximately. Then you're gonna have your red points, you're gonna go down south to the area of Long Caron.
And then the final color that we see, if we zoom in the map a little bit to cover the city of Vadex, there's another color there.
You skipped one color too.
Oh, I apologize. Let's go back down toward the village of Ubley.
Yeah, so we've got yellow next.
And what does yellow represent
So
in this
yellow
map?
would be after leaving Long here, going up into the village of Ubley.
And then from Ubley, the next color that we see, this point here that the hand is pointing to, can you describe what that is and when it is?
Yep, that would be on July 3rd at 6:43 a.m. That would be Sand Beach Road in the approximate area of Church Street or Tri-County Equipment.
Is that consistent with the location of where Sergeant Flores from the Bad Axe Police Department made contact with Mr. Talisman?
It is.
Now, there's quite a few data points in this area of the map, Officer Deakins. Can you tell us what street this is in the city of Bad Axe? There's quite a few points in this particular area as well. Can you describe what this area is?
Yeah, that's going to be.
And that's in Sanilac County, correct?
It is.
And then there are a number of points here in the village of Ubley. Is that fair to say?
Correct.
And is there a significant address there?
There is.
Now, Officer Deakins, is it fair to say that you also use these same data points to create a different visual representation for the jury's benefit?
Yes, I did.
Okay. And what is a vapor trail map?
So the vapor trail takes the same data points that we have in this map, but it makes it a little more visual. So it'll show a progression from the first data point we have on the second. It'll show the movements based on where the points all were, all the way through July 3rd.
So they go in chronological order, is that correct?
Correct.
Okay. May I approach the witness? You may. Officer Deakins, I'm showing you what's been marked as People's Proposed 76. Do you recognize that disc?
I do.
And what's contained on that disc?
This is the vapor trail map that I created, as well as the spreadsheets that were used with all the data points to create the map.
Are those the same spreadsheets that are on People 75?
They are.
Move for the admission of People 76.
Thank you. 76 is in.
Permission to display to the jury.
Yes, you may.
So, Officer Deakins, if you can just describe before we begin the vapor trail, what are we looking at here? What geographical area does this map cover?
It covers, you got Bad Axe is kind of just north of center. You've got Ubley that's pretty well centered. Minden City is gonna be slightly east and south of there, right there.
Okay.
So it covers kind of the southern part of Huron County, northern part of Sanilac County.
And now you also have a legend in the bottom right of People 76 that shows the colors that are indicated on this map. Can you describe what those colors are to the jury so they'll understand as the map progresses?
So these are the exact same colors from the first map. They describe, again, it's just broken down for clarity to show each piece of movement. So to Bad Axe, from Bad Axe to, and then into the village of Ubley, from village of Ubley back to Bad Axe, and then to the track stop.
And so I'm about to press play on this exhibit. What is that going to depict to the jury as they see the map start to move in real time?
Once you hit play, it's going to start showing movements. It's going to start leaving a vapor trail or a trail from each point to point to point.
Now, let me ask you, do those location points perfectly follow the roads that exist in both Huron and Sanilac County?
No, they couldn't.
And why is that?
Based on the GPS points, without having points like every individual second, and it's just not possible. The phone doesn't record every second. You're going to get some gaps. So it may not follow a perfect corner just simply because you don't have a data point in the corner.
Understood. And so the map has begun to move in real time, is that correct?
I wouldn't call it real time, but it is following the points chronologically.
Understood. Thank you for the clarification. And so I'm going to pause here. The blue line that we see is, you indicated what time period?
That was starting on the second at approximately 7:40 p.m.
And the map starts at what you believe to be his residence, that his being David Talisman's residence in.
Correct.
And then it goes directly to where?
Up to the area of
Then from the map turns, is that orange? Red? Okay. And from the red indicates his path of travel after he.
correct.
And where does that end up?
That goes down to,
Then the map seems to move across to Ubley Road and changes color to yellow.
correct.
Would that, what time period would that indicate?
That would have been shortly after 9 p.m.
Which is consistent with what you learned in your investigation of the time of the alleged home invasion?
Correct.
And then I'm going to press play again on the exhibit, and the map stays still for quite some time. Is that fair to say?
It does.
Why is that?
There are a lot of points that, honestly, that where the device stays for an extended period of time overnight.
And when does it start to move again?
Just shortly before 6 a.m. or shortly after 6 a.m.
And so we can see, it may be difficult for the jury to see, but is this slider down here at the bottom is still moving, correct?
Correct.
And that indicates the time frame that you have selected in this particular exhibit, correct?
Yes.
And so right now, if it were to say 04:10, that what time would that indicate that that the map is at right now?
If it said 04:10 or before 10 a.m.
Okay. Now it just moved again. I pressed pause and the time indicates 06:24. Is that consistent with your findings?
It is.
And that line turned pink, is that correct?
Correct.
And where does that end up?
It ends up back to,
And then if I press play again, does the map reset at the end, Officer Deacons?
it does. Unfortunately, the software I use doesn't allow it to stay up afterwards.
Despite my best efforts, I can't get it to pause. Where does the final data point indicate that, where is the final data point here?
It's going to be on Sand Beach Road, again, just like the previous map, near Church Street, almost in between like East here and Appliance.
And is that consistent with the location of the traffic stop that Sergeant Flores performed where he interacted with the defendant?
Yes.
Now, Officer Deacons, you created a third exhibit using the data points that you were able to extract from the defendant's phone. Is that correct?
That's correct.
What is a point progression map?
It's kind of like the vapor trail, only instead of showing movements by creating a new point each new point or a new piece, it shows the entire thing. It's gonna have the same colors. And it'll show some directional movement, but all the points will be on the map at the same time.
Okay. And you use the same data that you used to create the other two maps to create the point progression map?
Correct.
May I approach the witness?
Yes, sir.
Officer Deacons, I'm presenting to you what's been marked as People's Proposed 77. Do you recognize that disc?
I do.
What's contained on that disc?
The point progression map, as well as the Excel spreadsheets with all the data points to create the map.
And you used those particular spreadsheets to create this map, is that correct?
Correct.
And is it a fair and accurate representation of the data that you extracted from Mr. Talisman's cell phone?
It is.
People move for the admission of Proposed 77.
No objections.
Thank you. 77 is a,
Permission to display to the jury.
you may.
Thank you. And so, Officer Deacons, you said these were the same colors that we had seen before.
Correct.
And there's the same legend in the bottom right corner of People 77.
Yep.
Is that correct?
Correct.
And so can you just describe then to the jury what they're seeing on the animation here? So let's start with the blue line. What is that?
Again, the blue line was just the movement from the area by Mr. Talisman's residence to the city of Bad Axe.
And then the red line, the darker red line, I should say.
So we have the progression to the area of here.
And then the yellow line.
That would be from Pileski's garage, where the device stayed for a short time, up to the village of Ubley, where it remained overnight.
And then the, for lack of a better term, pink line.
That was from an Ubley back to,
And the green line.
and that's the movement to the point of the traffic stop on Sand Beach Road.
Now, Officer Deacons, I'm going to back this map up and I'm going to ask you to come over for just a moment, if you would. I'm going to zoom in on the city of Bad Axe. If you could please, with this pointer, could you please point where the Walmart store is located in the city of Bad Axe on that map?
So you got Walmart is up here. It's right there.
Is there an icon on that map that represents the Walmart Supercenter?
There sure is. And it's actually an accurate representation where it is.
Did any of your data location points indicate that Mr. Talisman's phone was ever at the Walmart Supercenter during the time that you examined it?
No.
To your knowledge, Officer Deakins, was the defendant in possession of his cell phone on the morning of July 3rd, 2024, when Sergeant Flores performed his traffic stop out there on Sand Beach Road?
Yes.
Is that how you came into possession of the defendant's cell phone?
It was seized by Sergeant Flores during that traffic stop.
Now, during a forensic examination of a cellular device, do you also have the opportunity to review any photos or videos that are on Mr. Talisman's phone during that extraction?
Yes.
Did any of these photos or videos depict Mr. Talisman with his arm in a cast?
Yes.
And were you able to observe any types of activities that the defendant was involved in while his arm was in a cast?
I did.
What kind of activities did you observe him participating in with his arm in a cast?
One of note that sticks out to me is that he's actually in what looks like a home garage, using like free weights to do some squats with his arm in a cast.
Okay. Now, one other question for you, Officer Deakins. If the defendant's statements indicate that he had his cell phone with him at all times during the dates and times in question, what determination can you make based upon the data points that you were able to extract from his cell phone?
Based on his statement that he had his phone with him, I would say that he was at every point of his phone.
Thank you, Officer Deakins. I have nothing further at this time.
Cross-examination.
Officer Deakins, you talked about the fact that Mr. Talisman's phone was never at Walmart.
Correct.
What exactly was your time frame, if you could just repeat that you looked at the data on his phone?
It would have been from July 2nd at approximately 7:40 p.m. through July 3rd. I believe the last point was 6:43 a.m.
All right, so at 1 or 2 in the afternoon on July 2nd, you did not get any data.
I didn't examine it for the purpose of creating these exhibits. No.
All right. And from your discussion of where his phone was in relation to Ms. Shauna's home, you said that someone had used the iPad.
Correct.
But there's no way that your data can show or has shown who that person was.
Correct. There are no point, nothing that says who used it at that very moment.
This is someone.
Correct. It was used at that time.
So you had just one other question so that it's very clear. You have no video of anyone accessing that iPad at the time, so it could have been anyone.
I have no video that has someone holding that very iPad at that moment. You are correct.
All right, thank you.
Redirect.
One question. During the time of the use of the iPad that you were able to determine from the forensic data extraction, where was the defendant's location?
Right in the area.
And where was Shanna Laviolette's location?
Thank
you. I have nothing further.
Cross.
On your own.
Status of the witness counsel.
We would like to have Officer Deakins made available for recall if necessary.
Very well.
Your Honor, with the admissions of People's Exhibits 1 through 79 and the testimony of the aforementioned witnesses, the people rest. Very well.
All right, members of the jury, the people have rested in this case. We will take a very brief recess and we will reconvene momentarily. Remind you again, not to discuss the case or any aspects regarding the case or look up aspects of the case. We'll reconvene momentarily. All rise, please. People have rested in this case. Ms. Roberts, how do you wish to proceed?
Your Honor, I would like to address the court and regarding a motion for directed verdict.
Very well, you may proceed.
I believe that the evidence that has been admitted so far as home invasion, first degree, entering without permission, has not been established. It's very possible that the fight ended up inside the house without Mr. Talisman going in to the home without permission. He was not armed with a dangerous weapon. There was another person in there, but I do not believe that it hits all of the 3 elements that are necessary in the jury instructions to reach a conviction of beyond a reasonable doubt. As far as assault with intent to do great bodily harm, again, the government has not met their burden beyond a reasonable doubt regarding the intent of Mr. Talisman. There's been no testimony by either Ms. Lavalette or Mr. Stevens regarding, or anyone else for that matter, regarding that Mr. Talisman intended to go there to either have a fight or to do some bodily harm to Mr. Stevens. Telephone interference. I do not believe that the government has successfully shown evidence regarding willful and malicious removal of the phone from Ms. Lavallette's hand beyond a reasonable doubt. And that there was no intent that Mr. Talisman had to prevent or obstruct or somehow delay the communication. As far as home invasion second, I do not believe that the prosecution has shown beyond a reasonable doubt that Mr. Talisman entered Ms. Lavallette's home without permission. And also that he unlawfully accessed the computer system. In cross-examination, Ms. Lavalette did say that at one time he did have permission to use her or access her computer, I believe. That would be the same for unlawfully accessing a computer system. And I think that would be it.
Thank you.
Your Honor, the court has heard the testimony as to the alleged home invasion first degree in Sanilac County, that the defendant entered the home without permission and committed an assault while another person was lawfully present. The intent in that particular instance can be shown, while not necessary, can be shown through the injuries sustained by Daniel Stevens, the homeowner at the time, that great bodily harm was indeed sustained as a result. As to the interfering with an electronic device, Ms. Laviolette testified that she had her phone in her hand when was attempting to call 911 when the defendant removed it from her hand and threw it into the corner of a closet. As to the home invasion second, Your Honor, Ms. Laviolette similarly testified that at the time of the alleged home invasion second degree, Mr. Talisman did not have permission to be in her home at that particular time, and the people would point out that a valid personal protection order was in place at the time on July 2nd of 2024. Therefore, even if permission was granted, there's still a court order barring Mr. Talisman from being at her residence. As to unlawful access of a computer system, Ms. Laviolette testified that at the time of this incident, Mr. Talisman did not have her permission to access the iPad. And Officer Deacon's testimony as to the forensic examination of the devices indicates that the only person that could have accessed the device at the particular time and place would have been the defendant. Your Honor, these are all questions of fact for a jury to decide. As the court is well aware, a directed verdict is appropriate only if considering all the evidence in the light most favorable to the prosecution. No rational prior fact could find that the essential elements of the crimes charged were proven beyond a reasonable doubt. People cite People v. Mayhall, 454 Mitch 1, page 6, the 1997 case. Here, Your Honor, the people have presented enough evidence for the jury to be able to make a finding of fact in each one of the charged counts, and would ask the court to respectfully deny the motion for directed verdict.
Thank you. Ms. Roberts, any rebuttal arguments?
None, Your Honor.
Thank you. All right, for purposes of directed verdict under SCR 6.419, specifically directed verdict of acquittal, directed verdict of acquittal is appropriate only if, considering all the evidence in light most favorable to the non-moving party, in this case, the prosecution, that no rational prior fact could find that the essential elements of the crimes charged were proven beyond a reasonable doubt. Indeed, the people that arrested in this case, the timing of the motion is appropriate, and the first issue is brought by defense is relative to the charge of home invasion, first degree. And here, bear with me. Our first element of home invasion, first degree, entering without permission. That the defendant entered a dwelling without permission. Does not matter whether the defendant got his entire body inside. If the defendant put any part of the body into the dwelling without permission, that is enough to count as an entry. In this particular case, the alleged victim testified that he was at his residence in Sanilac County. Mr. Stevens. And his testimony was he had heard the other occupant of the residence at the time, Ms. Laviolette, state, "Oh my God, Dave's here." And they heard a loud vehicle outside. He had heard a loud vehicle outside. He had told Ms. Laviolette to hide in the closet. And Mr. Stevens stated that the vehicle that approached almost parked on the patio. He testified that the storm door opened and that the defendant entered, was not invited in, and essentially the fight was on. Went into. He testified, and again, I have to back up a bit because the alleged victim, Mr. Stevens, testified that he never punched the defendant. The defendant, when he was interviewed by Sanilac County, indicated that that Mr. Stevens had punched him first. But again, the defendant, Mr. Stevens, testified that he was not invited in. And certainly, the first element would be a question of fact. That'd be a question of fact for the jury to decide. There's sufficient evidence for the jury to consider the first element, whether or not the entry was made with permission. There is contradictory testimony. However, the alleged victim testified again. The defendant was not invited in. The defendant's statement to Sanilac County was that he knocked on the door. The next thing that happened, the door was flung open and he was punched. Again, there's a sufficient question of fact relative to element one. Second element of home invasion, first degree, is that when the defendant entered, was present in, or was leaving the dwelling, he committed the offense of assault with intent to do great bodily harm, less than murder. I'll get to that element in just a bit. Third, that when the defendant entered, was present in, or was leaving the dwelling, either of the following circumstances existed. A, harm with a dangerous weapon? Absolutely not. There's no testimony, no evidence to indicate a dangerous weapon. But the second element could be and or another person was lawfully present in the dwelling. According to the testimony presented from Ms. Laviolette and Mr. Stevens, there were two individuals lawfully present in the dwelling at the time. So the court finds that the third element has sufficient information for the jury to consider that element. Again, I'll refer to intent in just a bit because I want to go to the next challenge, which is the assault with intent to do great bodily harm less than murder charge. Here, the prosecution must prove beyond a reasonable doubt that the defendant tried to physically injure another person. Testimony is presented by Mr. Stevens regarding the injuries that he has sustained as a result of repeated attacks. Again, I'm using that word, but the behaviors of the defendant in punching the defendant, hitting the defendant, pushing the defendant. Again, there's sufficient evidence regarding trying to physically injure another person. So there's sufficient information for the jury to consider. At the time of the assault, the second element is whether the defendant had the ability to cause an injury or at least believe that he had the ability. I believe there's sufficient testimony on the record to indicate the same. Again, if you look at the purported injuries of Mr. Stevens at the time, including a brain bleed, including, I believe, a concussion, as well as what the testimony indicated, that that would indicate there was an ability to cause an injury, and it was alleged that the defendant was the one that struck Mr. Stevens. Finally, regarding the intent to cause great bodily harm. Actual injury is not necessary, but if there is an injury, you may consider it as evidence in deciding whether the defendant intended to cause great bodily harm. Great bodily harm means any physical injury that could seriously harm the health or function of the body. The testimony from Ms. LaViolette was when she was inside the closet, she could hear Mr. Stevens either snoring when it was quiet or completely stop breathing. She further testified that she is in the medical field as a nurse. To what capacity, I don't know, but that would indicate to the court that she has abilities to understand sounds relative to individuals who may have been injured as a result of any situation, including an alleged assault and battery. Here, when you look at the actual injury, there is actual injury involved. The alleged victim in this case, Mr. Stevens, was transported to the Clarence Thumb region. He was subsequently transferred after we heard from the ER doctor to McLaren Lapeer, which is a level 2, I believe, facility, which treats these types of situations, including the brain bleed. I guess it'd be called a brain bleed. That's what the court is calling it, but the injury sustained the inside of the head, as well as there were contusions on the front side as well. So you can also consider the appearance of the home at the time. A door was actually taken off its hinges, and there was a point in time that tables were flipped over. Again, that's not necessarily indicative of great bodily harm, but when the door, according to Mr. Stevens, he essentially barricaded himself behind the door of his bedroom, which included using his one shoulder, I believe it was his left shoulder he testified to, but also his arms to keep the defendant from entering. The door was off its hinges. It was laying on the bed at the time. And when you put all of that together, there's a significant inference that when you consider that evidence, that the intent to cause great bodily harm is present. So as it pertains to at least home invasion first degree, because again, the second element, which I said I would go back to, whether the defendant entered, was present, or was leaving the dwelling, the defendant committed the offense of assault with intent to do great bodily harm less than murder. Court finds that there's sufficient evidence relative to that element as well. Hence, motion for summary disposition as to home invasion 1 and assault with intent to do great bodily harm are respectfully denied. The other concern was telephone interference. The defense claims that there's insufficient evidence to proceed to the jury. There's no significant question of fact. As a result, telephone interference charge should be dismissed. Well, to prove the telephone interference, the elements include the defendant prevented, obstructed, or delayed by any means the sending of an authorized communication through a telephone line or any other electronic medium of communication. It does not matter whether the communication was actually sent or received. Second, that the defendant did this willfully and maliciously. This means the defendant did the act on purpose and with the intent to prevent, obstruct, or delay the communication. According to the interview that was conducted of the defendant relative to Ms. Laviolette's cell phone, because that's what this charge pertains to, the defendant had told law enforcement that Ms. Laviolette had used the phone in an attempt to strike the defendant. And as a result, either the phone flew or wherever it went, but the defendant had no involvement with interfering with Ms. Laviolette's phone. That's the information provided so far. However, Ms. Laviolette testified that she had attempted to contact 911, and at that time, the defendant, according to her testimony, had grabbed the phone and threw it, and apparently was found under some clothing somewhere, but that was her testimony, that she was using the phone in an attempt to contact 911. And when you consider all of that evidence, considering the defendant's evidence, but I should say defendant's evidence, defendant's statement, in light most favorable to the people in this case, the court finds that there's sufficient evidence regarding the alleged prevention or obstruction of sending an authorized communication. And the court also finds there's sufficient evidence this is done willfully and maliciously. Now, again, the statement of the defendant was she used it as a weapon, and the court considers that. However, there's evidence on each side which indicates a sufficient question of fact for the court to consider, for the jury to consider, that is. So as a result, the motion for directed verdict relative to telephone interference charge is respectfully denied. The next challenge is to home invasion second degree entering without permission. Here, it's alleged that the defendant entered the residence at 302 South Silver Street without permission. And again, the elements does not matter whether the defendant gets his entire body inside, put any part of the body into the dwelling, that's enough. And in this case, according to the GPS data, now there's no, and I agree with defense counsel, there is no video or anything indicating that the defendant was at 302 South Silver Street. No video to speak of whatsoever in the on July 2nd. However, according to Officer Deakins, on that date and on the time in question, his cell phone appeared there through the GPS tracking and the expertise that he had provided. And when you consider that, the defendant, again, I believe he provided to law enforcement, he was never at the residence. Regardless of that, there's sufficient evidence that the defendant entered, at least there is an inference, at least some circumstantial evidence to indicate that there was an entry into the residence, because that's where the iPad was located. The iPad was located, or I'm sorry, the iPad apparently, according to the testimony of Officer Deakins, was used at or near the same time that the defendant's cell phone was located or pinged, so to speak, at the South Silver Street address. So when you consider that, that's more circumstantial evidence indicating being at the residence, but that's not the end all here. The part that's significant as well is entering without permission. Now, it has been alleged through statements provided by the defendant to law enforcement that there was contact between the two and that they would be at each other's homes. However, there was also testimony from Ms. Laviolette indicating that she did not give permission, that they may have had a relationship, but there was no permission to enter the home. And when you consider that evidence and consider even the defendant's statement, a sufficient question of fact exists. Secondly, in the element of home invasion second degree, that when the defendant entered, was present in or was leaving the dwelling, he committed the offense of unlawfully accessing a computer system. It is alleged by Officer Deakins again that at approximately the same time, at or near the same time on the date in question, that Mr. Talisman's cell phone is at or near 302 South Silver Street. It's around that same time that the iPad is utilized by someone. It clearly wasn't the defendant, I'm sorry, it clearly wasn't Ms. Laviolette. According to her testimony, she was not home at the time. She testified she was either heading toward Bay City Forestville Road or was there. So we have that to consider. Number two, she did not, there's no evidence to indicate she had the iPad with her. And so it doesn't seem logical to assume that it was opened or utilized by Ms. Laviolette. Circumstantially, it would indicate that if someone enters the home, cell phone is there, the application or the iPad is open and utilized. Facebook was initially looked at first, and then Snapchat, which according to Officer Deakins does have location services available to it. There's circumstantial evidence to indicate that the defendant unlawfully accessed a computer system, a sufficient question of fact, I should say. So when you consider all of that evidence, it clearly indicates the court sufficient evidence has been provided to overcome a motion for directed verdict of acquittal. As to unlawfully accessing a computer system, again, this might be a repeat, but again, circumstance or evidence provided by Officer Deakins circumstantially indicating that indeed the iPad was utilized around the same time, at or near the same time the defendant's cell phone pinged at the residence in South Silver. He testified that Facebook was open first and then Snapchat was open. Testified again, Snapchat has location services, which would indicate potentially the location of the alleged victim, Ms. Laviolette. Court finds that there's sufficient evidence that circumstantially that this was done so intentionally, can be considered as intentional because it appears from the information provided by Officer Deakins that shortly after that information was had, so to speak, that I'll call the vapor trail, the location of the defendant's cell phone went from 302 South Silver Street to the Bay City Forestville Road location. So I believe there's an inference there regarding intent. Again, without valid authorization is the third element. Yes, there has been testimony in the past that the alleged victim and the defendant would go to each other's homes, would share time, and maybe look at each other's phones. I don't recall that specifically, but at least they were involved together in some sort of relationship. And but that had changed, even though there may have been a weekend together or a day together, doesn't matter. What it indicates to the court is, according to the testimony of Ms. Laviolette, after their meeting, or whether it's the weekend or the day, the alleged victim testified that there was no authorization or permission to enter the home. There was also a valid PPO, personal protection order, at the time. Now, mind you, there has been testimony presented indicating that the PPO may have been, for lack of a better word, underutilized. In other words, it may have been used sparsely because there was contact between the two individuals during the time the personal protection order was in effect. Regardless of that, when you consider that evidence, again, Ms. Laviolette testified he was not in the residence, which hence would mean if you can't get in the residence, how can you go in to look at the iPad and allegedly find a location of Ms. Laviolette? So there is sufficient evidence relative to that element as well. Fourth, that the defendant did so to use the services of the computer or computer program or computer system. Again, according to Officer Deakins, Facebook does not offer location services, but Snapchat does. And according to Officer Deakins' testimony, when the Snapchat was opened, shortly after that time period, the defendant's cell phone is traversing from, it would appear to the court, there's sufficient evidence to indicate that the use of the service of the computer system, namely the iPad, could have been utilized for purposes of locating where Ms. Laviolette was. So the court finds that that survives a directed verdict of acquittal as to element 4. 5, when deciding whether the defendant acted without valid authorization to access the computer system, program, etc., you do not have to infer that he did not have authorization if the defendant accessed the computer intentionally unless written or verbal authorization of the owner. There is no evidence indicating written or verbal authorization of the owner, namely Ms. Laviolette, on the date in question. It's a little confusing regarding password protection. I believe Officer Deakins testified that there had to be a passcode to enter the iPad. Regardless, at this point, the parties did have a relationship prior to. Again, there's insufficient evidence for the court to consider that they're swapping passwords or information. There's nothing at that point. But again, when you consider that prong, again, I think there is circumstantial evidence to indicate that at the end of the day, there was still no authorization to access that iPad. And then the third prong, got access without using a set of instructions, a code or computer program designed by bypass or round pass. No evidence relative to that. So as a result, as to all motions for directed acquittal, they are respectfully denied. All right. Counsel, you ready to proceed in your cases? Okay.